that shines a light on the American justice system and its role in empowering the powerful to take from you. The justice system is the only branch of your government where an individual, rather than the collective, can make the system act for you. It puts power in the individual's hands, but it's broken and being used against you at a time when you need it most.
And we are live on Who Wrote That Up for You. Today is Monday, October 31st, 2022. I'm Sonia Ebron, a co-founder at Courtroom 5.
And I'm Deborah Sloan, the other co founder at Courtroom 5, and happy Halloween.
We have a wonderful show lined up for you today. In a few moments, we will speak with Mark M. Bello. Mark is a lawyer, he's a social justice activist, and he is a fiction writer, legal fiction writer. And so we'll be interested to get his perspective on some of those issues in the practice of writing as well. Before we get there, though, Deborah, what's on your mind today?
I want to talk from the files of peculiar law things. I want to talk a little bit about the law, the law on basically whistleblower law in regards to pro se litigation representation. Um, th- I'm sure most of you know what a whistleblower is. A whistleblower is someone who's employed by an government agency, or a corporation who basically exposes corruption, fraud, lying, criminality, and so on at that company. And there are a number of protections for whistleblowers. There are, the company or agency can't retaliate. Um, so there are a number of protections that are there for whistleblowers, but it's also a whistleblower can also be a part of a lawsuit, a False Claims Act, or a lawsuit. And the thing is, they can't go pro se in terms of their court appearances based on the whistleblowing. Okay, if you file a lawsuit based on the False Claims Act, you can't act as your own representative. And I thought that was very interesting. And of course, it's one of those peculiar law things that 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 kind of, yeah, you're like, oh, I don't understand this one. And so that's where I am with this one.
I remember the first time, and I was horrified to discover that I learned that I could not file a class action lawsuit as a pro se litigant. It just seemed terribly unfair to me, and I after I thought about it a while, I understood. Okay, I can represent myself. I have a Sixth Amendment right there to do that. But class action, you're representing other people, and so I couldn't do that. It finally made sense. I think this is the same thing. You're talking about, if I pronounce this right, Ketam lawsuits, and that's QUI, if I remember correctly, TAM.
Mm.
Ketam lawsuit. If I'm pronouncing it right, I'm not a lawyer, but if I remember it right, if I remember that correctly, you are actually representing not yourself as the whistleblower, but the interests of the government, right? You're representing the interests of the government, and you can't, as a non-lawyer, represent anybody else, right? You can't represent the government. And so that is the only way I make sense of that. But it reminds me, there's so many of these little peculiarities, as you call
Mm.
them, in the
Yes.
law. And I imagine there's some backbone theory of the law, way above my pay grade for sure,
Yeah.
that makes all of this make sense. I don't think we as pro se litigants necessarily need to know that backbone. We need to know the rules. We need to know the law if we're going to be in court representing ourselves. But this is one of those things where you don't know until somebody tells you, right? Because it doesn't, on the surface at least, make sense. And so that's yeah, one of
Mhm,
those things
mhm.
hopefully lawyers know, and that us regular people wouldn't necessarily have to. But we'll hear more about that. Hopefully we'll ask our friend Mark Bello to explain it to us in a moment. But before we get there, Who Wrote That Up for You is sponsored by Courtroom 5. At Courtroom 5, we believe the courts belong to the people, in particular to the people who use them. and we, the people, are coming to claim our courts. And so, if you are in court without a lawyer, or if you need to sue someone and can't find a lawyer to represent you, get yourself over to courtroom5.com. Try a limited version of our services for free, and we hope to provide some relief for you there. At this time, it's my great pleasure to welcome onto the show Mark M. Bello. Mark, again, is a lawyer. Mark is a social justice activist and a legal fiction author. And so we're going to talk about all of those things. But first, Mark, thank you for joining us on Who Wrote That Up for You.
Thanks for having me. My pleasure.
Mark, tell us how you got interested in the law and what you learned from your experience with it.
How I got interested in the law was it, like most kids. My parents emphasized getting a good education, and getting a good education involved going to college. And in my family, going to college wasn't enough. You had to go to professional school or graduate school, and since science and math and I didn't agree very well, um, I chose the social sciences, English and literature and uh, government, things like that. And going to law school was a natural choice for me.
Got it. Got it. Did you practice for a long time after
I
you left the school?
Well, I did two things with my law degree. One was practice law for about 25 years. The other was going into the legal finance business and financing litigation. So I own a company. I still own a company called Lawsuit Financial, and we provide money to people who otherwise can't afford uh, the cost of litigation. So similar to what you guys do with regard to unrepresented people, I do with regard to represented people. I provide the financial means for them to continue a lawsuit.
Got it. Fantastic. And as you know, that field has really burgeoned over the last
So
10, 12 years or so.
and
Absolutely.
between the two fields, I would say that's roughly 50-50 of my legal career. And then at post retirement, I started writing these novels.
Excellent. Excellent. What did you learn about the civil justice system during your long career
Oh
practicing
my!
law and
Oh my!
financing
Oh my
litigation?
goodness! Oh my goodness!
We
I
have,
I want to. I'm going to push back a little bit on uh, some of the things you guys are saying. I agree with you that the justice system needs some fixing. I agree with you that it doesn't do everything it should do. I agree with you that it's top loaded. That those with means and wealth can do better in the justice system than those without. If you look, for instance, at a um, minority criminal defendant who is broke, and you compare him with an O.J. Simpson, you can see that O.J. Simpson has a lot better means to get the system to work for him than to work for someone with far less income. Having said that, what I like about the civil justice system, anyway, is that lawyers typically work on a contingency fee basis. And while that can be very expensive for a plaintiff, it also provides him a lawyer without having to come out of pocket with cash. So you can hire the best lawyer in town on a contingency fee basis, and David can fight Goliath in the civil justice system. David can't fight Goliath in the criminal justice system. That's a completely different can of worms. But in the civil justice system, what I like about it is that money doesn't necessarily decide who does well.
I appreciate that, Mark. Absolutely, and we can certainly have a beer and discuss many of these issues. Let me
That's
just push back slightly there, and I think probably if you're talking about having a personal injury and you want to pursue a claim for it, there's a personal injury firm on every corner. You see the billboards everywhere that will evaluate your claim and see if they can represent you on contingency. I don't think you would find a personal injury lawyer in the country who would take any claim. And there are not necessarily because it's not a viable claim or the person can't receive some remuneration for their injury, but it's because it doesn't work for the parameters of the personal injury firm. There needs to be clear liability. There needs to be really simple evidence to collect, if any. There needs to be a dollar figure. All right. And so there are lots of people that leave personal injury lawyers unserved. Right. And so there's still a need for those. But you know probably better than I that the vast majority of people representing themselves in our civil justice system are on the defense side. These are people defending debt collection claims, home foreclosure claims, contested bankruptcies, whatever it is, right? These are folks that are, they don't have the option to go to a contingency lawyer and to get served in that way. So there's certainly a need for some other alternatives besides getting a lawyer.
no question about that. The typical client who's sued in small claims court is a
Right.
good example of what you're talking about.
Yep.
Um, uh, uh, on the other hand, someone sues somebody in small claims court, that person has means, and he
Right.
hires a lawyer and it screws up the claim of the person who brought the claim in small claims court because they can't afford a lawyer to take it into district court.
Exactly.
So you have that disparity of income on both sides, both the plaintiff side in small claims court and the defense side in small claims court. But your point is well taken. I agree with you. There is a level, there is a financial level at which you can't interest a lawyer in your case. That's for sure.
For sure.
There's also a quality level. You mentioned liability. The only thing I would push back on is you don't want even a citizen filing a case on his own where liability sucks, because the citizen isn't going to win, and he's going to waste his time, and he's going to waste the court's money pursuing a case that can't be successful. So you got to be careful about discussing what should be pursued,
Right.
not just the level at which it should be pursued at.
Absolutely agree with that. No doubt about it. Like any system, we've had this discussion on the show before. Like any institution, it's going to be abused
Yep.
And misused. And so this is certainly one of those instances. But
Although that's also a red herring. People shout lawsuit abuse like everybody out there is filing a frivolous lawsuit.
yeah,
That's nonsense.
that's right.
There are far more frivolous defenses than there are frivolous lawsuits.
I filed a few of them myself. I know what you mean there. That's true.
Have you heard the phrases that the AHA bandies about? Delay, deny, confuse, refuse.
No, explain.
Well, that's typically what a well-oiled defense corporate defendant and silk stocking law firm does.
Yeah.
They basically defend unreasonably, for lack of a better way to say it, as expensively as they can. So they simply litigate the person into oblivion. They delay the case. That's where lawsuit funding came in, by the way.
Right.
The advent of lawsuit funding was to help even the financial odds in a protracted piece of litigation where the defense has all the money and the plaintiff has justice on his side.
Right.
Justice should prevail, but sometimes economics get in the way.
Isn't that the truth? All day, every day. What's the phrase again? So I want to remember that. What's the phrase? Defend.
Delay, deny, confuse, refuse.
Oh, I love it. Yep, we're going to spin up a course on that. That's great. Fantastic.
I could
But
do a whole seminar.
Mark, I get a sense that this perspective of yours leads you to some social justice work as well. You want to share a bit about what you're doing and thinking along those lines?
As an author or
Uh,
post
I know,
retire post
yeah,
retirement? You mean? Okay.
yeah,
Uh, as a lawyer, you get to touch one client, maybe a group of clients at a time. You handle a caseload, um, and that caseload might be 10 files, it might be 100 files, it might be 300 files. But you're only handling cases for that limited group of people. And your law firm, if you have 4 or 5 lawyers, have similar caseloads, and you may have 14, 1,500 people you're representing at once. What I found is that the message, similar to the messages you guys get out, that injustices are happening, that the scales of justice are not always balanced. Those messages are, when you're practicing law, are achieved for a very few number of people. I can make a client happy. I can win that client's case. I can see justice done one client at a time. But when you write a book, or you give a lecture, or you appear on a show like this, you're reaching a lot more people at once than you ever could in your small little practice. So what I like about what I'm doing now is I get to appear on a radio show, and I get to talk to 1,000 people, 100,000 people, 1,000,000 people. I don't know whatever. But if I write a book and people read it, I get to preach, for lack of a better way to say it, to a number of people rather than one. So what I like about writing social justice rather than practicing social justice is the audience is larger, and I can get my message out to a lot a greater audience of people.
fantastic. Fantastic. That is great. We're going to take a quick break here, Mark. Have Deborah do her quiz for the day. When we come back, I'd like to talk to you about some of that writing
Okay,
and your practice of it.
happy to do it.
Great.
All right,
This is
Deborah.
so
Who
great. This
won
is great.
Friday's
Okay.
quiz?
All right. So Friday's quiz question was, what's a sham pleading? A sham pleading, such as a complaint or an answer, is a pleading that is factually false or frivolous and written for purposes of vexation or delay. It is something that is in bad faith and can be struck with a motion to strike. The winner is Will P.
Congratulations to Will
Congratulations.
there.
And today's quiz, true or false? You should bring all your witnesses to a non evidentiary hearing. You should bring all your witnesses to a non evidentiary hearing. Is that a true or false statement? If you want to participate in today's quiz, send your responses to quiz@courtroom5.com.
Fantastic. Looking forward to the answers there. And as always, with true or false ones, you have a 50% chance of winning there. So let's get your answers in. Let's bring back Mark uh, Bello. Thank you, Mark. Again, I forgot to ask you at the top of the
I
hour.
won't give it up. By the way, go ahead. Go ahead.
We'll give you a moment to show off here. Key Tam, did I pronounce that correctly at the beginning there? Is it Key Tam or something else? The
The
Whistleblower Act, I
whistleblower
believe
law.
it is.
The
Uh,
whistleblower is key Tim. Yes,
Key Tam, fantastic.
key
Thank you.
Tim.
I don't practice law, so I don't know my Latin as well as ought to. But I think there's another rationale that you might have for why pro se litigants aren't able to bring those claims.
Say that
Whistleblower
again.
law.
Ask me that again.
Why aren't pro se litigants able to bring ketam lawsuits?
I think Deborah made. First of all, statutory. I wrote that in the private chat. So what you can do and what you can't do is governed by law. And I'm going to presume I don't practice ketam, but I'm going to presume that the law requires you to have a lawyer. But Deborah's point is well taken. If you're representing a bunch of people, you can't represent a bunch of people as an individual. You have to have a law license.
Fantastic.
You're essentially practicing law without a license if you're representing other people in court. So unless you get permission from a judge, that's the same answer, by the way, as the class action example. You're representing more people than yourself. If you're just representing yourself, then you can do that. You know the old saying, "He who represents himself has a fool for a client." but that's a different. You're still allowed to do it.
Yeah.
I want to push back for a second on your on yesterday's question, the whole sham pleading thing.
Yeah, go for it.
We were just talking about it, and it's funny that it came up as your question of the day, because what a sham pleading is usually defined by the defense. They're the ones who say this is a frivolous lawsuit. This is a piece of junk. This is a piece of garbage. Dismiss it. I don't like having a defendant define my pleading. I want a jury to define my pleading. If a jury thinks it's a sham pleading, they'll no cause me, right?
Yep.
But let me get to the jury. I don't like the defense has no right to say my pleading is defective. Maybe a judge does. So most of the time when you hear the terms frivolous lawsuit or sham pleading, you're hearing it from the other side.
That's right.
You're hearing it from,
sure.
or you're hearing it from the Chamber of Commerce, who is the sponsor of tort reform.
Yeah.
So I would be careful with throwing words like that around. You defined it correctly. That is what a sham pleading is. But I would quarrel with the idea that what they call a sham pleading is actually a sham pleading, if you know what I mean.
Sure. Absolutely. And as you know, I mean, people make all kinds of arguments in court. It's up to the judge to decide what the what is going to proceed. So
well, every piece of litigation requires discovery. You're entitled to discovery. There's a period of time where you get to take depositions, where you get to send written questions called interrogatories, where you get to pursue an investigation while your case is pending in court, right?
Yeah. At a certain point. Yeah.
So you file a lawsuit, and maybe you haven't proved all the elements of your case yet. But you don't have to. You have to prove them in court when the trial comes along. So what I really hate is the idea that a defendant files what's called a motion for summary judgment or summary disposition early in the case and says that you can't prove the elements that your pleading alleges. The problem with that is, why do I have to do that now? I don't have to do that now. I'm entitled to take witness statements. I'm entitled to bring people into my office and take their depositions. I'm entitled to request records. I'm entitled to get evidence, and then you can argue that I haven't proven my case. But for a judge to dismiss a case, a month, 2 months after you file it, because you don't have enough evidence yet, I don't have to have enough evidence yet.
We could have a long conversation about that.
How dare you? How dare you dismiss my case?
Let's say, for the point of argument here, and I want to get to your books, Mark, but I love this.
Me too. Me too.
Oh, he definitely has to come back here.
But I get aggravated about stuff.
I do too. But let's say I sued you for the use of that particular headset, that you shouldn't have any microphone in front of your face. Maybe it should only be on the side or on your cords or whatever,
Right.
because God said so. God commanded, okay, that there should be no instruments like that. And you are liable because you've injured me due to my belief in God with that microphone. Now, tell me, point me to the judge
I'm
that would
gonna,
allow
I'm
you to
gonna,
conduct
I'm gonna
discovery.
piece. I'm gonna,
And that is the point. You might actually, I don't know what the claim would be, but let's say you found one, right? And you allege the proper elements of that, and I allege the proper elements of that claim against you. That would get me to the discovery stage, right? But there's no discovery I could have that would allow me to prove that claim.
right.
And in that circumstance, your motion for summary judgment would be welcomed by the court, right? Uh, to get me to get me from, keep me from wasting more of the court's time. It's those sorts of situations, I think, and this
I
goes back to Deborah's sham pleading argument. There are rules on these things that,
no
again,
question.
help the court just run an efficient judicial
No,
branch.
I'm certainly not sitting here saying there are no sham pleadings. There are. I'm certainly not sitting here saying there are no bad, ridiculous, phony, garbage lawsuits. There are.
Yeah.
I'm not saying that. What I am saying is that a lawsuit needs the system to allow it to develop to its ultimate conclusion. And if you're unable at the proper time to prove the elements of your case, then it ought to be dismissed, but not before that. Now, that's different than the case you described, where there is no
Claim.
rational basis
Right.
for the lawsuit to be brought in the first place. I don't like blue-eyed people, so I'm suing you for having blue eyes.
Exactly.
Stuff like that. I mean, you can't. That's an obvious. That's something you obviously can't do.
Absolutely.
And by the way, a judge would probably fine you
Yeah, exactly.
for court costs for bringing the lawsuit.
That's right, and absolutely should. Mark, before we run out of time, I do want to introduce the writing that you do. You're a fantastic author of a variety of legal fiction. Give us a sense of what brought you to writing fiction after such a long career in the law.
Well, I never really. I mean, I wrote a lot in college. I was an English literature major. You write as a lawyer, you write briefs and you write pleadings, and there's a lot of writing involved. I never really fashioned myself to be a fiction author, but when I was in my 30s, I handled a case against the Catholic Church, a clergy molestation case where two boys were molested by a priest, and that was the case of my life. And it took me 4 years to get my clients justice, and the church did despicable things, lied, hid evidence, covered stuff up, made me work very hard to get a solid recovery for my clients. The experience was troubling to me, and I always wanted to write a book about it. I thought it was going to be a nonfiction book. I thought I was just going to tell the story of the litigation. But the longer life got in the way, and I raised my kids, and I practiced law, and I started my second business, and it wasn't until 30-something years later, when I retired, that I wrote the book. And it turned out to be fiction. I thought I could write a more compelling fictional account than I could a nonfiction account. And that turned out to be true. I created a kind of a clandestine CIA type organization within the church, whose job it is to silence witnesses by any means possible, and it creates a very interesting novel. Um,
Mm.
the novel is written and it's released, and it does pretty well. And I think I'm done. I've written my book. It was the bucket list item of my life. I'm done. And then the 2016 election came along, and I don't know what the politics of your audience is, but I will candidly tell you I'm not a fan of Donald Trump. So I don't like blowhards or bigots or narcissists, and he's all three of those things. So I'm watching the election unfold, and I'm saying, my God, if he wins, this is the type of president he'll be. And
Mm.
I decided to write a book about it. And I wrote a fictional account of a bigoted blowhard narcissist who becomes corporate billionaire who becomes president of the United States. And I released the book just as he wins the election. And I get accused online of doing a hit job on the president.
Mm.
And my response was, I wrote the book before he became president. If you see a similarity between my president and your president, that's on him, not on me.
I
Now,
love it.
once I wrote that book, by the way, the first book is called Betrayal of Faith. The second book is called Betrayal of Justice. Once I wrote the second book, I realized I could write books about topics in the news, for lack of a better way to say it, and put my own legal slant to it, my own political slant, for lack of a better way to say it. And I started writing books about topics like white supremacy, police shooting innocent black men in traffic stop shootings, a school shooting, the border crisis, the Me Too movement. And then finally, the last book was simply a whodunit. So I kind of departed from. I didn't name it Betrayal. I named it You Have the Right to Remain Silent, and it's about a young woman who comes home and finds her husband murdered. She's caught. She turns out to be the principal suspect, and she becomes catatonic at discovering her husband's mutilated body, so she can't speak for herself. Hence the title, You Have the Right to Remain Silent. And it's an interesting whodunit with a political slant. The accused is a talk show host, a conservative talk show host. Her husband is a progressive congressman who's murdered. So they think it's some kind of politically motivated, incompatible couple murder mystery, and it turns out. Read the book.
I love it.
Yeah,
I love it.
yeah,
I recommend it.
definitely.
Absolutely. Betrayal of
but the other books are kind of social justice, ripped from the news kind of topics, like I described.
excellent. Mark, I'm going to
Wow.
share your website with our audience here, markmbello.com, on the screen there. Where else can people find you and your work online?
All the books are available on Amazon and Barnes and Noble and most places where you can buy online books. They're not available in bookstores. I'm a self-published author. It's hard to get your work in bookstores unless you're published.
Absolutely, absolutely. And we will share your online presence, your social presence as well in the show notes. Mark, it's been a tremendous pleasure
Awesome.
to have you on Who Wrote That Up for You. Thank you so much. We look forward to having you back again soon.
Anytime. I enjoyed it. And if you,
I'm sorry, I cut you off there too quick, Mark.
I said if I can help you with a legal question in the future, let me know.
We will. We will take you up on that. Fantastic. Thanks
I'll fight.
again.
We'll have a debate with Deborah.
She's better than I am. I guarantee you that.
Great.
Thanks again. Fantastic.
Oh, that's
Fantastic.
awesome.
Love that.
Okay.
Yeah. Yeah, we've got a lot to talk about with Mark. So let's see if we can't get him scheduled for the next season as well. That's all we have for you on Who Wrote That Up for You. As always, thanks for tuning in, and we will see you tomorrow. Thanks, everybody.
Are you feeling beleaguered, angry, or afraid, as if things are spinning out of control and you're powerless to stop them? It's easy to just let things slide and hope they don't get worse. But they often do get worse. The thing is, you're not powerless. Our courts belong to us, and their purpose is to give power to the powerless. Don't let your grievances pile up without redressing them. You can handle this in court. Or, if someone takes you to court, you can take them to school.